Hello class, welcome to another pre-recorded lecture. In this lecture today, we'll be sharing on privacy and privilege communication, And so you may ask, what is privacy? What is privacy? I'll be sharing with you a couple of definitions of privacy. So privacy is the control over the extent, timing, and circumstances of sharing oneself with others, and oneself can be related physically, behaviorally, or intellectually. So much control you have over the extent, the timing, and the circumstances of sharing oneself with others. For example, persons may not want to be seen entering a place that might stigmatize them, such as a pregnancy counseling center, clearly identified by signs on the front of the building. Privacy, again, is about people. And this is different, where confidentiality is about data and a relationship. So, but privacy is about people, a sense of being in control of access that others have to ourselves. The right to be protected, that's privacy right there. The right to be protected. And that is has to be related to in the eyes of the person. So for example, in research, where the research participants are research subject, as it relates to privacy, it has to do with the eye of the participant or the subject, and not the researcher or the IRB. Another definition of privacy is privacy refers to an individual's control over personal data that, while universal to all individuals, is nevertheless specifically identifiable and to be withheld from public access. And those identifiable information are like birthday, gender, marital status, income, health status, religious beliefs, and genetic information. So, how much control the person has over this information being withheld from public access. And so privacy, again, has to do with individuals or people, while confidentiality has to do with relationship and data. So what is privilege communication? What is privilege communication? Privilege deals with the patient's or client's right to exclude from a legal proceeding communications made to a treating clinician or provider. So again, as we can see right here, with privilege communication is where the patient has the right to exclude from a legal proceeding or a case in court communication made to a treating provider or clinician. So again, with privilege, it has to do with exclusion of information in a court case that person has made to a treating clinician. So again, it's all about whether or not if the information is necessary to be disclosed for this legal situation. The term privilege refers to the legal right of the client or patient to prevent disclosure of information revealed in the provider-client relationship to others. So again, privilege is where the person has a legal right to prevent that disclosure of the provider-client relationship to others. Privilege communication protects clients from having their confidential communications disclosed in court without their permission. So again, privilege communication has to do with a court case or has to deal with a situation in court where the individual can exercise that right to have, some part or all of the information being protected or, being disclosed prevent the disclosure from being in court. As it applies to healthcare information, the term privilege involves a legal rule of evidence that gives a patient the right to exclude from a legal proceeding certain communications made by the patient to a clinician or provider. While the ethical duty of confidentiality is universal, the legal concept of privilege is not uniformly recognized or applied in all jurisdictions. So again, confidentiality in the United States is universally, recognized, while privilege, there might be differences across jurisdiction. And so again, privileged communication is where the person has the legal right to exclude information from being divulged in court that was provided in the provider-client or provider-patient relationship. Let's talk about the general criteria for determining privileged communication. What are the criteria for doing so? Criteria for determining privileged communication. Confidentiality is essential for maintaining the relationship. So again, you see that confidentiality is essential to maintain the relationship. That's a patient-provider relationship, or that's a client-clinician relationship. It's confidentiality is important to keep that relationship going, because the absence of confidentiality, that relationship will break down. Next one, the communications originated in the confidence that they would not be disclosed. So it originated in a confidential relationship, and that was very evident in the get-go of that relationship. The relationship is so necessary for the functioning of our society that, in the opinion of the community, it should be sedulously fostered. And so again, this relationship is essential. For example, the patient provider relationship is necessary because it brings a lot of benefit to society as it relates to health care. Criteria for determining privileged communication continues. The injury that disclosure would cause to the relationship is greater than the benefit to the litigation process that would be gained. So in other words, when you do a cost-benefit analysis on the situation, you realize that the damage of the disclosure will be greater than the benefit that would be derived from disclosing the information. And so we see that the benefit of non-disclosure is higher than the disclosure itself. So cost benefit analysis, we see that benefit is greater for the non-disclosure than for the information than the litigation process. What we do know is that physicians, attorneys, and the clergy and other professional groups in the United States have claimed that their relationship with their clientele meet these criteria and therefore are deserving of privilege, which privilege communication, that some of the communication be withheld or all of the communication be withheld from being divulged in court. So again, physicians, attorneys, and clergy. So let's talk about exceptions to privileged communication. What are the exceptions that we have to privileged communication of the information being divulged in court, or what are some situations that, these are exceptions that will, affect privileged communication? One, in cases of dispute between provider and client, that information will have to be disclosed in court because it's essential to the dispute between provider and client or provider and patient. When client raises the issue of mental condition in legal proceedings. So again, this is where the client is in terms of mental status, probably the person raised the issue that they are not mentally competent and so forth. And so what happened is that, or they're not in a good state of mental health to be tried in court. And so the court would mandate the psychiatric treatment, and in that mandating, the provider of that psychiatric treatment would have to report to the court. And so there is no privilege communication in that sense. When client's condition pose a danger to self or others, so in the cases of suicide, there is no privilege, or in the cases of homicide, where there is a specific person that is at rest as it relates to the client disclosing that, then there is no privilege in those situations. In cases of child abuse or neglect, and in child abuse, we're talking about physical abuse, sexual abuse, or neglect. In those cases, there are no privileged communication. You cannot exclude that from the court proceedings in the patient, provider, or client clinician relationship. When provider has knowledge that the client is contemplating commission of a crime, so privileged communication you cannot claim privilege in this situation because of the knowledge of a crime. Next one is for purpose of involuntary hospitalization. So this is where probably the person is suicidal, and you have to hospitalize the person, or the person probably has a manic attack, or those kind of things, and need to be hospitalized involuntarily. So in those cases, if it goes to court, you cannot have privilege. During court-ordered psychological evaluations. So in court, the court has ordered a psychological evaluation or psychological evaluations, then you cannot claim privilege. When the provider has knowledge that a client has been a victim of a crime, then in those cases, cannot claim privilege. If it goes to court and then the information is requested, then the client cannot claim privilege in that sense, or the patient cannot claim privilege in that sense. In cases of harm to vulnerable adults, so this are related to probably individuals with intellectual disabilities, in also the elderly population as well, that they cannot defend themselves. And so again, privilege communication, privacy has to do with people, while confidentiality has to do with data, and then privilege communication has to do with court proceedings. And just also be aware, as we have just talked about, that there are exceptions to privilege communication. And so I hope and trust that this lecture has been beneficial, and that it has helped you or caused you to think about privacy and privilege and how we interact with that as chaplains.